My goal in this time is really not to spend too much time lecturing. I think you guys have had a tremendous amount of that. I've sat in a couple of the earlier sessions, which have sounded exceedingly enriching, actually. I wish I could have heard even more. But what I hope to do in the next while that we're together is to discuss a little bit more in depth some of the complexities having to do with the issues of political and partisan gerrymandering. To do that, though, it would help me tremendously to know a little bit more about you all. I won't ask you each to introduce yourselves, but I would like a little informal poll just so I can get a sense of the areas that you come from and what sort of level of involvement you've had with these issues before. Can you tell me how many of you all in this room are either admitted or closet lawyers? Okay, so a few of you in the room. How many of you all are then on the mathematics side? Mathematical quantitative analysis people, okay, great. And let's see, I've not covered either people in the press. Okay, no people in the press, that's interesting. Okay, an area that I haven't yet covered. Interested citizens who don't do any of those things but are good voters and are really interested to learn more. Okay, great, great. This is good. I talked to a variety. Has there anybody I have not yet named? Educators, okay. Good citizens. Any other groups? Just give me a shout out. Let's see who I haven't named. So educators. By the way, educators, high school, elementary, okay. High school, okay. Social studies, government, none of the. History and government and math, great, good. Every good mathematics person needs to start early. What's that? Politics, great, good. So I talked to a lot of these groups. I don't think I've heard a group yet that I haven't named, although this is actually the first group of mathematicians that I've spoken to primarily. As you may or may not know, I do kind of spend time in both worlds. I thought I heard some hissing all of a sudden. I'm going to assume that wasn't against mathematicians. I spend a lot of time in both worlds, in part because I'm one of those weird people who spent a lot of time studying both on the social science side to understand the analytics behind redistricting before it got cool, and then the emerging legal side. And so I find myself talking to groups that don't often understand each other, and it's really exciting to me to have met, at least over the phone, Moon, who expressed a really strong passion about this issue. And I hope it opens the door to a lot more opportunities for these different communities to speak to each other, because I think there's a great deal of potential for more learning and education on both sides of the street. And so that's my hope, at least in part, about what we can accomplish together today. I don't plan to talk for the full hour. What I'd like to do is spend probably like 40 minutes or so kind of talking about a few concepts that I think are worth thinking through as we're both on the legal side and the social science side, trying to work through some problems that courts and, frankly, decision makers on the political side are going to be thinking through, in fact, are thinking through as we speak. As you might know, even though we typically work off of a cycle of about 10 years to engage in redistricting, I know that came up today in the District Builder session, there are any number of places, many of which I spend a lot of time, that are engaged in redistricting now in response to court orders. So a lot of these questions remain live, and in fact, a lot of the sort of challenges that underlie the legal claims that started these court battles in the first place are still being worked through. And so the conversations I'm going to introduce some today and invite you all to think some about actually are questions that haven't been fully resolved. And it actually welcomes, I think, a rich and lively debate, both about what concepts mean, but also, and this may be more relevant to the mathematicians in the room, how we go about figuring out where a concept is at issue. That is, how we measure how well a state has done to accomplish a certain goal, or to put it differently, at what point is a line crossed beyond which the court should intervene. So I'll talk a little bit today. I think some of this stuff has been addressed earlier, so I won't belabor the point, but what I'll invite you all to do is slow me down if there's a point at which you want more discussion about. But what I'd like to do in any case is once we get through this, these comments that I make, I'd love to get your feedback. And as we, I think, get through about like an hour and a half, we should have more than enough time to engage pretty fully. Okay, so enough about introduction. Let me say a couple things about more specific cases that I've worked on. I don't usually talk in depth about the projects, but I can say I've worked in about half a dozen states on a variety of cases, and some of which I'll talk about later tonight on the panel, that involve challenges involving line drawing. Usually when I get called in, a party knows it's about to get hosed, or I'll put it more bluntly, they know they're going to get screwed and they know they're going to have to go to court. And the goal is to try as best you can to make the best case you can to the majority, to set up what may be a lawsuit, and in the long term may politically be the basis on which you run an election that says, hey, the other side has really subverted the process. We need a better opportunity, a better system to allow your views as voters to be reflected. My roles have varied between consulting people in that legislative process, to serving as an expert witness, to serving as amicus counsel. And in all of those roles, though, what you see very early on is this interesting moment, as I suggested, where you realize the lawyers, while pursuing the goals that they're trained to pursue in law school — I've taught a number of them, and they are, focused on narrowing the issue to a very specific set of questions that the court can easily answer, that is on a, on or off switch. It is either on the right side of the line or it's not. And on the other hand, you've got politicians who are obviously thinking about their own futures, right? They've got actually to run in these districts no matter what happens, and they want to have a situation that's most favorable to them individually, and then ideally, if we can get that far, to the party. And often what you see in all of these settings is they can sometimes clash. And what I want to talk about is the way in which those clashes sometimes produce conundrums in the law. So I do want to offer first one thing that I always like to say to groups, and I'm so excited, as I say, that many of you all want to get engaged in the question about reform in a number of different perspectives. What I always say is about reform, what this guy, one of my favorite characters in The Wire, always reminds us about the importance of being skeptical and questioning and careful about the concept of reform. I don't know, how many of you all watch The Wire? Anybody? Okay, good. So I'm not totally speaking Greek. Brother Muzan, right, hired contract killer, part-time philosopher, tells us something really significant in the season of The Wire where the city government gets the bright idea to knock down all of the public housing projects, right? And that goal is to get rid of the scourge of the drug trade, presumably. But what you see slightly under the surface, and what Brother Muzan spots, the moment he shows up and sees what's going on, he says, there's a little funny thing about reform. The question isn't always what intends to be sort of the thing that replaces what's being knocked down. The question is who benefits from that process. And it's usually not the target or the community that's being claimed in public. And so often you have to think carefully before pursuing a reform, one, to think carefully about whether or not a particular fix actually does all of the work it's claimed to do, but then who are the winners and losers, right? Now, that's not always obvious, but it's worth thinking carefully about. So these are my caveats to anybody that thinks about reform. Certainly pursue it, but always be careful and consider three things. First, always make sure that you're considering people. There's an inclination, and I know it, and I understand it, I've experienced it. This is often presented as a clash between titans, right? The Democrats versus the Republicans. You should know, just so that you have my biases on the table. I've sued Democrats, I've sued Republicans. My goal has been about the policy and the principle, not about the people who are running for office. They're relevant, but they're not determinative of how I think the rules ought to be applied. So always remember that this is about people and voters. They usually are brought in as a sort of tail-end consideration. But those are the interests that should be brought in first. When we talk about the idea of what a community of interest is, for example, we rarely actually engage questions about what people who live in these areas actually think. There haven't been until recently. Again, some of the sophisticated technology described in our earlier session give us a sense of what is, I think, around the corner. But we haven't traditionally in this field had an easy, accessible means of collecting views about what people think their districts ought to look like, or what the communities are that people actually readily identify on the ground. Usually that's done from the top down. The elites are looking and deciding, well, that is a community, and that's a community we ought to decide to prioritize over contending ones. Well, we're now at the space where individual communities can do that themselves, and we need to think carefully about ways of actually encouraging that and making that more accessible. Second, and this is my hobby horse, I'll tell you, it's much of my research, take race seriously. I have gotten into debates with any number of people in the academy, sometimes in the political world, about various forms of the following argument, and that is, well, look, this race thing is a thing of the past. We should be thinking in a purely colorblind fashion, and therefore any attention to race whatsoever is counterproductive, is politically, let's say, disruptive, and frankly, it can be constitutionally troubling. Those are the arguments I usually confront. Now, I think those are interesting theoretical arguments. I certainly believe there's a limit beyond which race should be considered, but I think to deny the fact that people, among all the different identities that they express and live on the ground, certainly in the place where I'm from in the American South, to deny race as one of those features is troubling. And it's troubling because it actually reflects a number of things that go beyond politics. And so if we deny that, in my opinion, it cuts out a significant opportunity for people who have had a particular tradition of marginalization and exclusion from political representation. It prevents them from actually being able to live that out now. We've not been very long in an era where we've actually thought about race as one legitimate consideration, right? Since 1965, traditionally, we've kind of marked that. That's not been that long, certainly compared to the life of this country. It pays, I think, all of us to take account of the fact that people actually associate in schools, neighborhoods, and churches around race, among other considerations. So to deny that, it strikes me as troubling, even if it is complex. I'm not suggesting it's easy. There's no Pollyanna version of this narrative, but I think there is a very significant harm to be had for us all if we deny the fact that race informs some, if not all, of the way in which people think about their public and private lives. So respect racial identity. And then the last consideration actually is tied to the second one, and that is, look, the world is not full of bright lines. We like to think in law world that something is or is not legitimate, or that the rule is that it is either correct or it is not correct. And there are certainly cases where that's true. In the world of politics, however, what you find is that standards are usually what govern as opposed to rules. And standards are multi-factor tests that are context-specific, right, that take in a multitude of factors. Those defy simplicity, right? And what we have to do, therefore, often is think about it from the social science perspective, sort of as a sort of multivariate set of considerations, right? And when we do that, sometimes it becomes messy. Interpretation becomes significant, but that's sort of the point of discourse, right? We arrive at a conclusion based on a long discourse about what we think the data is telling us, or what we think the public as a whole is discussing. All right, enough of that. That's my sermonette for the day, but now let's get into some of the weeds on the law. So I think, correct me if I'm wrong, I missed the earlier discussion today and yesterday about the sort of legal landscape, but I got the sense that both of those presentations gave you a very general discourse about where the law is, that is on race, gerrymandering, and partisan gerrymandering. Is that fair? I don't want to retread ground that has been covered. So let me just jump right to what I think are the complexities that are left. And it's the complexities, as I suggested earlier, that really ground some of the challenges that I think social scientists, thoughtful citizens, people who are not lawyers can actually make an interesting contribution. So I'm going to just kind of race through it, but I'm going to focus in on what I think the conundrums are. So just to remind you, when we talk about racial gerrymandering, right, the sort of court has delivered a sort of jurisprudence from the 14th Amendment since about the 1990s, back when I was here in college in this area, that race can't be the predominant motive in a legislature drawing districts. It can't predominate over other traditional districting principles. Judges in practice are looking through the process to determine whether or not there were some things that were abnormal, or the results of that process led to things that are bizarre in terms of their shape. So when you get districts that look strange, when you get a process that doesn't fit the typical narrative of how legislation, in particular redistricting legislation, gets adopted, the court's going to find a need to look more carefully. Usually in this process, though, what you hear legislators who want to defend the districts that are being challenged, they always will tell you, almost always, certainly since the 1990s, hey, we didn't have any consideration of race at all, right? Race had nothing to do with what we did. You hear this in a lot of different contexts, but there's a problem here. The problem is we actually have a federal law that demands attention to race to some degree, right? While the rules that I was describing and that you already have heard about with racial gerrymandering is you can't take race too much into account, the rules that say that you actually have to assure that you aren't ignoring potential harms that existing racial groups have in redistricting. So again, it's probably been described to you at this point. The goal of redistricting in this context is to draw it just so that you take race enough into account. But that clashes with the potential defense that a lot of people want to offer is, well, we didn't take race at all into account. I literally heard this just now in the state of Alabama, where the legislature, in trying to correct a plan that was declared unconstitutional by the court, a plan that took race too much into account, the line drawer, with a straight face, says to the court, well, we've drawn this new map based on the old map, but we didn't take any account at all of race. Now, you don't have to be a lawyer to think of the logical problem here. If a plan that took race too much into account is the basis of a plan that you now say takes race not at all into account, it's kind of a hard sell. But this is one of the challenges that we have. How do we respect the anti-discrimination claims that say we can't discriminate on the basis of race, and therefore we need to make sure that the potential effects treat racial groups that have had a tradition of being excluded fairly, but at the same time we don't let race override everything else? How do we do that? And usually where you find the complexity further exaggerated is in the South. Party and race are inherently, in a lot of places, linked. You probably have heard this discussion already, so I won't belabor the point. But partly due to our history, we have a pretty strong bifurcation of the political identities that have sort of flipped since the 1960s, where African Americans are, in fact, pretty much across the board in this country, the most easily identifiable Democratic group that's out there, right? White Southerners in particular are a little bit more mixed, but certainly more than about 60 to 70% of the time you identify a white person, chances are you will find a person who identifies as a Republican. Now you throw that in a pot and call it a state, you've got a pretty interesting politics where race doesn't totally define whether you're a Democrat or a Republican, but it can do so. It's a pretty reliable predictor. And it becomes further troubled when race defines how you draw the districts. Because if you're drawing districts so that, say, you identify readily African American majority districts, you've also drawn Democratic districts. So how do we figure out a rule that establishes the proper extent to which we could involve race into the drawing of districts? That's really the hard challenge, particularly where we know that voters, at least to date, have naturally identified, at least in the current era, using race where African Americans are very heavily Democratic and whites not as much, but pretty strongly tend in the South towards the Republican Party. Now, one answer, just to give you previews of coming events, is, well, how can we influence the way people make their choices, right? If we want to have a more sort of robust politics, maybe black voters should start to find Republican candidates to support. And the response to that is, well, if there were Republican people who actually would go after black voters, maybe so, right? But that's a sort of hamster wheel that we don't have to run on today, but just know that that's out there. All right, so we've got this conundrum in race, again, where we see a world where we've got an attention to race, but a limit out there in the law that says, well, don't take race too much into account. Partisan gerrymandering is a little bit different. I should say, by comparison, race gerrymandering has been heavily litigated. Again, I told you, there are cases sitting out there right now that are in flux. In fact, I'm going to go to North Carolina probably in the next couple of weeks to deal with that problem. But these are cases that have gone on pretty much from pillar to post, from the beginning of the decade until the end of the decade, just in time for the new process to go forward. And courts have been pretty active in litigating in this area, or judging litigation in this area. By comparison, partisan gerrymandering, not so much, right? The court gives us a fairly relaxed standard, partly because they disfavor engaging in rules that look partisan, right? You've heard that stuff before. This has not been the Supreme Court statement, but one of the statements that I often teach in election law comes from the Ninth Circuit, which the Supreme Court affirmed, which is not quite embracing the full analysis, but it's law that's out there and that's relevant. A Ninth Circuit case that involved Republicans, oddly enough, in the 1980s, who made an argument that the Democratic legislature basically undercut any opportunity that they had for serious representation in Congress. They lost the claim. And the Ninth Circuit, in reviewing that claim, made the argument that, well, you know, we know that you probably could have gotten more seats, but who are we to tell you how many more you could have gotten? You've heard this argument before. What's fascinating is they sort of hint at a standard that says, well, the only way in which we think the court should be involved, says the reviewing court in this case, is where the party like you who's complaining is totally wiped out at the polls. You have zero representation. Well, think of the practical truth of the case where that's true, ever. Right? There's always going to be one seat that's out there. And in this case that I'm describing out of California, the argument of the court was, well, wait a minute, we're not even going to just look at the congressional seats that you're challenging. We're going to say that, well, even if you don't have any congressional seats, it's possible that your party can be represented at the state level. Or in fact, even at the federal level, where you've got, say, a president of the United States who happens to be from California and a member of your party, that's some evidence that you're not totally wiped out. So as a practical matter, right, the absolute ability of a party to actually challenge this kind of standard successfully is kind of difficult because the purpose of the gerrymander, you've seen this already, is always to preserve at least one seat, right? You got to put these people who are pesky voters who don't support your majority party somewhere. So why not oversaturate them in at least one or a few districts, and you can just sort of shunt them away. Makes the world safe for the rest of us, right? So the challenge as a practical matter, at least up to now, has been rather unrealistic for plaintiffs trying to challenge partisan gerrymandering. And you can hopefully see some of the reasons why, at least to defend the courts for a minute, why this might be a little bit problematic for them to try to wade into, right? One, competition is sort of a feature of why we think politics works in our country, right? We think as long as we have, right, market A that has a Democrat and Republican in it fighting each other for domination, that maybe somehow the public gets a chance to choose, and as a result of that, right, the right answer over time kind of comes about where that representative interest is sort of, fully realized. That even if the Republican doesn't win in a heavily Republican district this time, there have to be 2 or 3 times more where, on average, right, the right answer comes about. Well, obviously, we're getting to the point now where there's a tremendous amount of research that suggests that we're better at crafting districts that are predictably, indeed reliably, ones that produce a certain outcome. This prediction, at least in the 1980s, might now be a question that the Supreme Court wants to address. As I said here, the last point in this is, at least from the 1990s, we were left with a point where the court was at least on the fence about whether or not the law of partisan gerrymandering was a viable area that plaintiffs could mine. That is, whether you could go to court and challenge a state that had drawn districts having violated a standard called partisan gerrymandering. The court says, well, okay, we think that exists, but we can't quite tell you a workable standard to determine whether or not that rule has been violated. This is sort of Justice Kennedy's sort of contribution to the I guess we can call it the standards in partisan gerrymandering, in that he hasn't given us a standard. In fact, he was excoriated the last time he issued an opinion out of Pennsylvania for actually doing just that. That the typical approach of the court is to say whether or not a plaintiff wins or loses, but to tell us why the plaintiff wins or loses, and for future plaintiffs, what one has to do in order to win. And Justice Kennedy hasn't told us that. And as you probably know, in October or so, the Supreme Court is going to find once again an opportunity to consider whether or not there is such a standard out there to determine whether or not a state that uses partisanship to drive its decisions about how districts get drawn violates some part of the Constitution. Now, just as a preview of coming events, this is now my own opinion on the matter. Justice Kennedy has told us, at least as a hint, that he can't tell us a standard, but he seemed to believe that it's possible that the First Amendment gives us a theory for under sort of idea of association, we think, how a partisan gerrymander might actually undercut sort of core fundamental values. Now, most of you all know a little bit about the First Amendment, if not a ton about it. And the concept actually goes back in some ways to what I suggested earlier, this idea about a party being totally eradicated. If it's impossible for a party to do that basic thing that we think parties do, which is bundle people with like values together to support candidates, then Kennedy seems to suggest, well, maybe that's a place where we say the court should get involved. But how do we measure that? Is it ever the case that a party is totally unable to do that kind of work? And to what extent are we going to say that that's the only way in which a party can be active, right? Parties do more than that, right? Parties raise money. Parties issue press releases, right? Parties do a lot of organizing outside of the electoral realm. So the challenge, I think, is going to be, at least through a First Amendment lens, how do you articulate to Justice Kennedy a workable standard? Now, the claim that's being presented to the court lies more in the 14th Amendment side of things. Just know that that's out there. But my point in saying all of this is the conundrum here is that we think competition is a good thing, but eventually, if the courts have to be involved, they are in some ways going to regulate competition. Now, we do that in the antitrust world, right? We don't allow one company to gobble up so much of a market that they get to control the prices and the supply available. But in this case, it's a hard call to ask a court, at least from their perspective, it's a hard call to ask a court to intervene in a way that would disrupt the normal competition that exists between Democrats and Republicans. And the hard question is, well, if they don't do it, then who does? All right, so those are the sort of existing conundrums. We've got on one hand, the court heavily regulating an area where they're saying, well, not too hot, not too cold. On the other side of the street, you've got the court being asked to think about partisan gerrymandering, but they're doing it in a way that suggests that they have to get involved in a place where courts, which are unelected, remember, are really loath to go in and articulate a standard for fear of saying, well, if we do it in any particular way, we may basically consign either the Democrats or the Republicans to a standard that they can't easily fulfill. And that fundamentally shifts the sort of balance between each of those parties in the party competition of election. I don't know what the correct answer to that is, but know that those conundrums are out there. And that's really the hard challenge throughout all of this. Now, I'm not going to give you any silver bullet answers to any of this stuff right now. What I'm going to offer you, though, are some thoughts about what I think, at least in the place of redistricting, can get us a little farther along the path to trying to develop some of these answers. I would normally spend a little time sermonizing about stuff I think each of these communities could learn from. I'm going to skip that right now, in part because I'm going to do that in a panel later tonight. But you know what? If you want to hear more of my little sermonette on what I think academics, courts, and lawyers each could do better, I'm happy to talk about that in the questions. But I promise I'll bring that up a little bit later. What I want to get to now, though, are solutions, at least, again, hints at solutions. And to do that, I wanted to at least present what I think on the table at present represent sort of the way in which most reform proposals are being framed. And I think these are good, but I want to at least group them for you to be on the lookout for. The first set of reform ideas fall under this idea of prohibited considerations. That is, right, a world in which we're not going to tell you exactly how to draw districts, but we're going to tell you is what you can't do when you think about drawing districts, right? So there are going to be certain places, California among them, right, which has led the way in some ways, in the recent move towards independent redistricting. They created a citizens commission. I take it by now you've heard about the California system, so I won't recount that. Anybody from California? Okay, one, gotcha. Okay, two. All right, a little underrepresented for the rest of the population, but that's good that you're here. So what California does, though, is set up an independent commission which takes the decision-making away from the legislature, right? That's a structural consideration. But what they also do, and this is why I bring it up, is to say there are two things that we won't allow you to do. You can do a lot of different things, but two things they won't allow you to do are, one, take partisan data, that is past voting practices, into account in drawing districts, so that when I draw a line around a given neighborhood, I can't know, at least the line drawers officially can't know, whether they have in the last, say, 4 or 5 election cycles voted heavily Democratic or heavily Republican. What I also can't know is where the incumbents live. Now, you know enough about this to know that usually everybody knows where the incumbents live, and they're very keen, right? Because they don't want to pick a fight if they don't have to. But note what that does, right? It pushes, on the positive side, a sort of new way of thinking about, well, what does identity mean in this context? We have to now search for different models for defining identity. And maybe it invites the public to give us new conceptions of what identity means. What it also does is makes a lot of incumbents very jumpy, because, right, they don't know what's going to happen. An incumbent might be matched up with 1 or 2 other opponents that are incumbents. An existing incumbent might be moved out of the existing district where they happen to live. And that obviously creates a lot of problems. Now, I will give you the other side of this, because I don't mean to suggest that, California is the best thing ever. It's got good weather right about now, but that's another story. With respect to the question about incumbency, though, I've told you that the line drawers can't know any of that information. You, the public, certainly can. And what is kind of a challenge is figuring out how to wall off what you know in the public from what I know as a line drawer. Because what may happen, and this typically happens, right? You tell me there's a prohibited consideration. I tell you everything that is great about this district, except the one thing that actually made me draw this district in the first place. So, in fact, some of the criticism of this system is, well, if you want public feedback, you can't stop the public from thinking about a variety of different considerations. On the other hand, there's still some benefit in saying, well, you can say whatever you want, but in my drawing a final map, I've got to take into account just those things that we collectively on the Line Drawing Commission find important. So fine, make your arguments about all this other stuff, but they better be persuasive on their own terms. And under the law, we more or less allow that, right? As long as we don't have but for causation, right? But for the fact that you were interested in protecting this incumbent, you wouldn't have favored this plan. Well, as long as there are other reasons why you would have favored the plan other than the incumbent protection, we might all find, comfort in the fact that we arrived at this for sort of neutral, let's say non-prohibited reasons. All right, so that's one answer. Another answer, new structures. Now, I mentioned the California example already. Here's another. So suppose we don't take the legislature out entirely. And let's suppose we also say, this is another of my hobby horses, I'm a lawyer and I teach lawyers. I like lawyers getting work, but I don't necessarily love litigation. I don't like litigation on its own terms because it's costly. And it costs, yes, we get paid, but it also costs the taxpayers money. And when the state gets sued and the state loses, little known fact, the state pays its own fees. The state pays the fees of the winner too. And if you think about the cost of doing that in a plan that everybody knows is faulty, but the politicians want because they're the majority and they want to give their shot to get what they can, it creates a rather inefficient, one, but ultimately silly system. And so it would save us all a lot of time and trouble if we had, let's say, a first run at considering whether or not the plan that's been adopted is legal or has a shot at being legal. What the state of Florida has done in answer to this is to set up a system whereby the state legislature draws the maps. It is given a set of considerations, but it is then immediately passed to the court for review. No need for a lawsuit. In fact, the plan is not implemented until the court has passed on it. And at least in its first iteration this cycle, the Florida Supreme Court actually did send elements of the maps that were adopted back to the legislature for consideration. And in doing so, it gave specific direction. Its view was that on certain criteria, certain numbers of those districts were not in keeping with what they understand the structures to the principles to direct in the case. What this prevented, if you think about by comparison, this prevented plaintiffs from having to go to court and initiate a lawsuit. It also stopped another important feature of this whole process, which is time. Okay, it didn't really stop time, but it did stop election time. And by that I mean this. Elections are the trains that always run on time, right? That is, there's always going to be an election. Asterisk, sometimes not, but very rarely. Judges won't stop an election from happening. What happens if you know that there's a patently unconstitutional map that is actually in litigation and it's a month or 2 months before an election? That election happens even under a map that might be later found unconstitutional. And if you can see what the potential harm is from that, right? An illegal map producing a legislature that might be unrepresentative, they're fully empowered to pass laws as much as they want. There's no court that's likely going to tell them, we forbid you, you are not going to be permitted to pass any legislation until we've gotten this adopted. That's way beyond what anybody would say the power of the court is. The challenge, therefore, is avoided when you have the court, at least in this case a state court, review in an early instance the legitimacy of a plan before the plan gets adopted. Now, we have a version of this, or at least had a version of this, under the Voting Rights Act called preclearance that essentially did the same thing, that was eliminated in 2013 by the Supreme Court of the United States, but nothing prevents a state from adopting a measure like that. on its own, using its state court system. So again, it's a way of assuring that the public as a whole understands that the legislature has done its homework and tried to comply with the rules, and to the extent that they've fallen short, the court gets the opportunity to tell the legislature, look, we're not going to tell you exactly what to do to remedy this, but we are going to tell you that there are problems associated with this map in these particular ways that don't comply with the following enumerated principles as we understand them. So feel free to go back, redo the work, and send it back, and we'll take a look. The final example, a special measure. This is actually something that sometimes gets done at the local level that actually gets the public more engaged. There is a rule at times to have a line drawing process, I think it actually was discussed today, explicitly involve public comment. Bless you. And the public comment actually reminds the legislature that, or whoever the line drawing authority is, that its job is to make sure that once it draws these lines, it's got to actually reflect the interests that have been expressed through the process. So one easy way of doing it, and you see this sometimes, is that the legislature or the deciding body has to draw the map and explain its reasoning. That is, go back to the evidence as an administrative agency might and show the ways in which it complies with or, right, contrasts with the existing evidence that's been put on the record. You don't necessarily have to follow everything that was done, but to the extent that you're not going to do it, say you're not doing it and say why you're not going to do it. Now, that's not necessarily a legal answer, but it does give these elected members some sense of accountability and transparency. And that's actually, to me, an important feature, because none of this works, to be frank, if the public doesn't hold the people who draw these lines accountable, right? I mean, lawyers can go to court, the judges can give you a very strong opinion, but at the end of this entire process, there's got to be this thing we call an election. And if people aren't held to account, either successfully giving them credit for what they did or exercising some penalty for not complying with what the public's interests are, then the point of this all is sort of a ruse. Again, people will get paid from it, but in terms of the public's benefit, I'm not sure that there's much to be had. All right, so last comments I need to make, and then I'll open it up for questions. My general principles, as I say, I don't believe there's any one fix that's going to cure everything. I do believe the more people that get involved and interested in this, that's good. But I do think that whatever anybody that talks about reform usually will call me about asking my sort of, up or down gladiator vote on a particular fix. And to be fair, I do think some work in certain contexts better than others. But I don't think that there's a one cure-all way of solving this problem throughout the entire country. But I do think that there are principles that you should at least consider when thinking about the efficacy of any one of these fixes. So the first one is, my view is always, any fix that we think about needs to be data-driven. We need to think about facts, right? Not fake facts, but facts. Now, I say this because there are extreme cases, right, where the line drawing authority says, we want what we want and that's it. We got the votes, period, stop. I don't care what you want. Right? Those are easy cases, right? That's bad. We don't think that's really public-minded, very democratic. But what about the following case? Suppose I were to tell you that I've got to decide, let's say, how many districts I'm going to draw in a state that has been heavily disfavored in the past. Or let's say districts that have had not a lot of growth in the past, but all of a sudden has had in the last cycle ridiculous amounts of growth. And it's been growth from people outside of the state. They come with a particular viewpoint, and so we want to make sure that we have districts that reflect that viewpoint, whatever that is. Now, I could decide how many districts I want to draw. I could do it arithmetically. I could do it based on the viewpoints of the people who are elected, right? They have a sense of who's there, and they talk to people. Now, if I have to choose between those two, I've got a preference. You might choose differently, and that's okay. What I want to suggest to you is, though, whatever view you take on the evidence, whether it's anecdotal from individuals or aggregate data-driven, you need to actually be explicit about what those reasons are. As I say here, anecdotal evidence, I think, ought to be disfavored, but it doesn't mean that they shouldn't have any relevance at all. I've been thinking in particular about a case where there's a discussion about how many districts should have a percentage of, let's say, African Americans in it. to comply with some considerations to make sure that African Americans in a particular part of the state are not unfairly represented. They have a fair shot at, electing a preferred candidate if they want to. Well, you could do that arithmetically. I look at past elections and come up with roughly an estimate of what that percentage ought to be within a range. What a couple of cases we've seen out of Georgia and Alabama involved, however, was a line drawer going to the person who happened to be from that area and saying, well, what do you think? Again, not totally irrelevant, but less relevant than evidence of past performance. And I think one of those challenges is thinking about, for the court's perspective, what is it that we're asking legislators to do when they consider whether or not the evidence that they take in to determine these questions has merit, is consistent, is this kind of stuff that you can put against objective testing. Because if you don't use that, let me just sort of play this out. If you don't do that, it's everybody's opinion, right? And everybody's got one of those. How do I know that your opinion isn't informed by your interest in being reelected if you're an elected official? I might do a little bit better if I ask the public who happens to be from that area, well, what do you all think? I could run a poll. Well, that's helpful. But we need to have metrics that give us a better handle on objectively, small o, what's going on out there that gives us a handle on how we ought to draw districts, whether it's, again, a percentage, number of districts that's drawn, et cetera. Because otherwise you give the line drawer a lot more discretion, and I think in a dangerous way, for deciding what it wants to accomplish without seriously thinking about what's going on the ground. All right, I've said enough of that. Here's a second. Consistency, right? This is a shocker. You have a rule, you need to apply the rule across the board. What you often see in court cases is this. We had a series of considerations we had to take into account. It's a very complex process. We don't quite know exactly how it worked out in any given district, but know that we took it all into account, right? I don't know if there are any number of administrative law cases that are this way as well, right? I'm not very happy with the share of the goods that I was given. I challenged the decision maker's formula for determining my share. The decision maker says, oh, it's a complex formula. Don't worry your pretty head about it. There's just so much there. But somewhere lost in the details is the ability of anybody to look over the shoulder of the decision maker and make an assessment. Did you do what you said you were going to do? Now, in this world, I don't say that it's impossible to come up with an exception to the rule. Of course, the world is complex. I said that earlier. But if we're going to have exceptions, they should be exceptional. And the state should have to, I think, should be able to articulate the whys of what it did and what it didn't do. And what you see in a lot of these cases, now and again, the state will not be all that smart and put things on the record that suggests, well, okay, they said they were doing this rule, they were using this rule in a consistent manner, but look, there are 5 or 10 or 20 ways in which they didn't do that. They could have done it to be consistent, but they haven't. States are getting smarter about that, but it's important to think about consistency in applying any of these rules. All right, last point, transparency. And I've talked about this already, I won't belabor this point, but at the close of all of this, we should be learning something, right? Yes, there are going to be winners and losers. There are going to be people who are excited and people who are maybe in despair about any line drawing process. That's just a fact of life. That's true. But one of the things that I think you should always judge any process, whether it's a board game or, for that matter, a redistricting process, is the extent to which you're willing to play the game again, right? That is, the person who loses, doesn't get all that they want, has to feel confident enough in the process that they can, on the next run, if they do some adjustments, if they work hard, if they get more voters, that they can have a shot at getting a better shake out of the process, that they get a better share of the goods that are out there. Part of that rests on transparency. I've got to know why I didn't do as well as I did this time. Or I have to know what the considerations are that the line drawers are taking into account, how they're balancing things out. To the extent that you keep this stuff veiled, right, that's exactly where the devil lives, right? Because I can make a decision in any of these circumstances about, sneaking in considerations to help Representative Farmer Joe or Banker Tim, right? And dress that up in the pretext of, well, we're following the rules, we're following objective considerations as much as possible. But this does the work also of allowing courts to more easily ferret out the places where it can teach the rest of us in the public, but the legislature in particular, about how to do their job more effectively. So my view in all of this is, look, this is all enhancing a procedure that helps right? Democrats and Republicans do their jobs in line drawing or as independent commissions, but it really helps us all collectively be more effective interveners in this process to tell the legislature what we want. We've got 10 years, every time a district is drawn, for that matter, to collectively organize and figure out what it is we want out of a district map, who our allies are, what our issues are, how we actually articulate our message. One way that we do that most effectively is by knowing what the rules of the game are and what the decision maker is going to take most into account. So my goal in raising these is essentially to say, look, I don't believe that there's any one fix to any of this stuff, but what I do believe is that if we take these concerns into account, we can at least know what we're getting into. We can at least tweak a proposal so that the public can have a fair shot at engaging. And that if we have to go to court, we do it in a way that doesn't sort of have us chasing the hamster wheel around and get to an answer that actually allows us to have elections that are legitimate, that get more people involved in voting.